Hi, I'm Peter Tragos, host of the Lawyer You Know podcast and YouTube channel. The saying goes, everyone hates lawyers until you need one. Well, I'm here when you need one to answer your questions and give you insight that you didn't know you needed. Along with my partners, Pete Sardis, the professor, who has a finance and business background, and George Tragos, my dad, and the consigliere, a criminal defense giant, we can answer any questions you have. Welcome back to the Lawyer You Know, and we're going to continue unpacking the facts of this Ronnie O'Neal double murder trial here in Tampa Bay. And as we continue to do this, today we're going to break down the very last day of the trial, which was last Friday. But today is Monday, June 21st, 2021. We expect closing arguments to happen today. We expect the jury to be out and deliberating today and maybe even come back with a verdict. So we're planning on doing a YouTube live tonight at 7:30. If you're going to join that live, please make sure you subscribe to this page so you get the alerts for it. Hit the bell and leave me an emoji in the comments of a thumbs up so that I know you will be at that live event tonight at 7:30. Look forward to seeing you there. Last time we had a ton of time for questions and answers for everybody that was in that live, and that was a ton of fun. That was my favorite part of it. So make sure you join us at 7:30 tonight. But for now, we're going to unpack that last day of trial. And just like every other day, it was crazy, and it included some unusual events that don't often happen in trials and some specific events to this trial that were just strange and need some legal analysis. So we'll start with one of the prosecution's last witnesses, which was Detective Dirks, who has since retired. But he was one of the main investigating officers in this case. He listened to a bunch of the 911 tapes. When Ronnie was crossing him, he tried to get into the fact that some 911 tapes were missing, especially the all-important ones. But the most damning answer that the officer gave, and another opportunity for us to show the difference between a pro se defense attorney and a real criminal defense attorney that's been trained, is the officer gives this answer to a question.
Can you draw any conclusions that I committed any murder in this case?
Yes, that's why I arrested you.
So he says, I arrested you for her murder. That is absolutely objectionable and usually inadmissible for an officer to explain that he arrested the defendant, why he arrested the defendant, because of that cloak of innocence the defendant wears. So many people, especially back in the day, believed everything an officer said. And during jury selection, we always say, just because the officer arrested the defendant, you realize that doesn't mean he's guilty of the crime. You realize that that's a different burden. You realize that just because an arrest was made does not mean the defendant should not still be presumed innocent. That's what the case law says. But Ronnie O'Neal walked right into the fact that the officer was able to say, and the officer is obviously experienced since he is retired and he's been doing this for a long time, so he knows any opportunity he gets to say, that's why I arrested you for her murder. That's damning, and the jury hears that and they think, well, if this highly trained officer that sees this stuff every day thought that there was enough to arrest this guy, maybe we should just convict him. Which is why we, as practicing criminal defense lawyers, would never let that answer come out. We'd never ask a question that would elicit that answer, and we would object to that answer because it is not relevant to whether or not he committed this crime. The fact that the officer made an arrest does not prove or disprove this case, and that's something we would never let fly, but Ronnie O'Neal, again, representing himself, might not know that and allowed that answer to come out. Next, we're going to jump to Ronnie's opportunity to call witnesses, right? So there was one witness that was a 911 operator that talked about the fact that some of these 911 calls that we heard aren't on the call log, and that shows that everything's been tampered with. I think he was able to show that there were some discrepancies, there were some inconsistencies in the evidence that we heard and what was in the call logs, but not enough to show this entire case was created and fabricated by law enforcement in the state attorney's office. And that's the problem. In his opening statement that we broke down at length, and we'll link in the comments, he was guaranteeing and promising, showing all this destruction of evidence and creation of evidence, and that this was all tampered with. Yet all we see is, one call maybe missing, but we have the recording, so who cares if it was on the call log? But if that one's missing, maybe more are missing, he's saying. So I understand the argument, but it doesn't show this big conspiracy, which is what he promised in his opening, which is another problem. Lawyers don't want to overpromise and underdeliver. There's been a book written by a lawyer, Underpromise and Overdeliver, because lawyers don't want to say too much in opening, because then the jury doesn't believe us by the time it gets to closing, because none of the stuff we said the evidence is going to show actually happened in the trial, which is why you have to be careful as a lawyer in your opening statement. Another witness that Ronnie called was a minor neighbor, and we're going to show you the video of a part of his testimony. Ronnie called this witness, and listen to what this witness had to say.
His wife started trying to run away, and he went and he grabbed her, and she was on the sidewalk, and he stood over her, did this like striking thing like 3 times, and he shot her.
So Ronnie actually called this witness, and this is the problem. I don't know if he deposed these people. I mean, he's had deposition transcripts, especially from his son, where he was impeaching his son with it. I don't know if he had a deposition transcript of this neighbor, but this young neighbor, this minor neighbor, says he heard a gunshot and then saw Ronnie chase his girlfriend outside and bludgeon her to death, basically. That's damning evidence, and that's something we didn't have before. I mean, we didn't have another witness saying that he murdered his girlfriend outside of his son, who he tried to pick apart and discredit him as a witness, but now a witness that he calls, that he raises up. It's very strange. I don't understand how this helped his case. If anything, I think it hurt it in a grave way and was really a big hit to his self-defense defense that he's trying to put together with these witnesses. Another interesting fact about this is Ronnie's son and now this witness he's called have both been minors. And as you remember in the George Floyd, Derek Chauvin trial that we broke down a few months back, having minors witness these crimes can actually get you enhanced penalties sometimes. So let's keep an eye on that of whether or not that comes into play here because we have some more minor witnesses. And throughout the evidence or the defense's case, which is what Ronnie gets to put on, he really wanted to dig into the fact that he made this 911 call saying his wife attacked him. Okay? That is the main piece of evidence for his self-defense defense outside of his testimony, which isn't going to happen. He invoked his Fifth Amendment right. He tells the judge he is deciding not to testify. Let's play that clip.
Have you made a decision yet whether or not you're going to testify on your own behalf or whether you're going to exercise your right to remain silent?
I'm not. I'm going to exercise my right to remain silent.
Okay, very good.
Now, I'm sure that outside of the clips that we're seeing on the news stations, there was a long colloquy between the judge and Ronnie where she explained to him his rights again. She explained to him the rights that he's waiving. She explained to him that once you do not testify, you can't go back, and this cannot be a reason that you appeal the case because you think you would have been better off if you would have testified in the future. Okay? They read him a long colloquy. They ask him all sorts of questions to make sure he's competent and make sure he's able to waive this right to testify and invoke his Fifth Amendment right. Now, here's where we're really going to jump into the weeds of being a trial lawyer. The prosecution now has a very important decision to make when it comes to their closing argument and when it comes to Ronnie's closing argument, how and when they're going to object. During our live event that we did last week, I guessed that Ronnie was going to testify, and my reasoning was that's the only way he really gets into all the evidence that he said is going to come out in his opening. That's how he gets to all the evidence of how his daughter died. That's how he gets to all the evidence of how it was self-defense outside of that 911 call, which he also said white demons attacked him, which I don't think any of us think that actually happened. The only way for him to actually get into this stuff and call it evidence is for him to say it from the witness stand. We always say in opening and closing as a lawyer, anything the lawyer says is not evidence, and you can't use that as the jury to make your decision when weighing the evidence. If a lawyer just said it, but you didn't see a piece of evidence or hear testimony from the stand, you can't consider it as actual evidence in making your decision. So all these arguments Ronnie's been making, everything he said in his opening statement, none of that is evidence and none of it can be considered by the jury legally. That's what I would hammer down on if I was the prosecution, to say, just because he said it in opening doesn't mean it's evidence. Doesn't mean you actually heard it in this case and you have documents to actually look at. He may have said there was tampering. He may have said it was self-defense in his opening, but nobody testified to that, and that is not evidence. But here's where it gets very, very scary for the prosecution. You cannot at all intimate that the fact that Ronnie O'Neal did not take the stand, the fact that he invoked his Fifth Amendment right, you cannot tell the jury or ask the jury or even intimate to the jury that they should hold that against him. Okay, so they can't say, if he would have taken the stand and said it, it would have been evidence, but he didn't take the stand, therefore there is no evidence. You can't do that. I can do that here explaining it to you guys, but they can't do that in trial. That's an automatic appeal. If you say the reason that you should convict this guy is because he didn't take the stand, you lose on appeal every time. So it's a very, very fine line the prosecution has to walk. But what they can do is say, look at the law. Look at the jury instruction. The only thing you can consider is evidence. Let's talk about what evidence is. It is witness statements from the stand. It is documents produced to you. It is evidence produced to you, actual tangible things and witness statements and 911 calls that you heard. That's the evidence, not what we the lawyers say, not our opening statements. And I would even say I would put the onus on us, intimating also not Ronnie's opening statement, right? So this is why A lot of people think it was a brilliant decision for him not to testify because he cannot be cross-examined, right? And that's the strategy, if anybody's wondering. The reason he didn't testify is because he didn't want to get cross-examined. If he goes up there and gives his narrative and says, this is what happened that night, now the prosecution gets to say, why was there blood all over your body? Why was there gasoline all over the place? Why did you light the house on fire, right? We haven't heard a lot about that. Even Ronnie hasn't argued that his wife lit the house on fire. So why did Ronnie light the house on fire? What are the white demons? Who are the white demons? What happened to your daughter? I know he's intimated that his wife killed his daughter, but nobody's testified to that. There's no evidence that anybody killed his daughter except for Ronnie's son saying his dad, killed his sister. That's the only evidence there is, and that's what I would say if I was the prosecutor. I would say the only evidence in this case of the murder of this young girl is that her dad did it. The only evidence in this case of all these crimes is that he did it. That's the only evidence you saw, okay? That's what we hammer down on if we're the prosecution, because there is no conflicting evidence because Ronnie O'Neal did not take the stand. He did not give that testimony that could have been evidence for him to hold on to, and in my opinion, it was a mistake. He should have taken those cross-examination questions, answered them the best that he could, done his best to explain what happened that night. But he had to take the stand and explain his self-defense. He had to explain what happened inside that house and give the other side of the story that his son did not tell or his son did not remember because of the shock and everything his son went through. There were holes in his son's story. Ronnie could have filled those holes, and he didn't. Now, again, people are going to tell me he doesn't have the burden of proof. I agree with you. I agree he does not have the burden. He can just poke holes all day. But he created this duty. He created these promises and guarantees in his opening and then fell flat and didn't actually follow through with them. And I think the jury's going to hammer him for that. We're going to hear the closing arguments today. We'll talk about them at the live, and eventually we're going to get a verdict. But I want to know in the comments, what do you think? Do you think it was the right decision for Ronnie O'Neal to decide not to testify? Or do you think he should have testified? And I'm not talking about holding it against him. I'm not talking about convicting him because he didn't testify. I'm saying all the things he said are not evidence. And that's what would worry me if I was a criminal defense lawyer, is I don't really have anything to hold on to at this point. And this trial, it just continues to be so fascinating, okay? And so different and unlike any other trial I've ever seen. Let me know what you guys think, and make sure, like this video and subscribe to our page. Be with us tonight at 7:30 p.m. so we can talk through whatever happens on Monday at the Ronnie O'Neal trial. Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com.